all the things that protect students' educational rights on the outside, federal laws also protect them on the inside. And so drawing on a source of these rights, right? This comes from, I put the links at the bottom, but the Office of Civil Rights, which is part of the US Department of Education, and then the Department of Justice's Education Division. These two authorities often work together to give guidance to the states on what laws apply to students and how to interpret those laws and how school districts should apply those laws. If you're not familiar, OCR in particular is a great resource for parents when you're looking into what protections apply to your student with a disability in the school context and other contexts, among other areas, right? If they're an English language learner or minority student or other facets. Anyway, so all those protections in federal law apply in carceral settings. So equal access to academic coursework as other children, right? Equal access, equal opportunity among male and female students, meeting the needs of English language learners, FAPE, right? The special education entitlement that you all are too familiar with probably. Avoiding discriminatory discipline. We talked about that a bit, I think in week 2, based on race, national origin, sex, disability, etc. Providing auxiliary aids and services for effective communication. That's coming right out of the ADA, hearing or speech disabilities. And then ensuring communication also with parents. Parents with disabilities have entitlement to be part of their kids' education. Applies on the outside, also applies on the inside of prisons and jails in Virginia, and all over the country. So that comes from this Dear Colleague letter that OCR and DOJ put together about, and it shapes sort of the framework of how education rights should be delivered to students. And the reason this is so necessary and why it's so important now is, like, we used to not do this, right? We thought of kids as in the prison system, in jails, as sort of, even if it's juvenile, we're kind of done with you, right? Or we're running this separate program, separate but unequal from the students on the outside. And so there was a lot of movement in 90s and 2000s just to improve that, both in Virginia and nationally. And so now DOJ and OCR have said, here are the themes that students in juvenile justice secure care settings should get in their education, right? Here are the themes that those educational agencies that are delivering educational to those students, these are the themes that they should abide by. So safe, healthy, facility-wide climate that prioritizes education, provides the conditions for learning, and encourages the necessary behavioral and social support services that address the individual needs of all youth, including those with disabilities and English language learners. Second, there should be funding, necessary funding to support educational opportunities for all youth within these facilities, comparable to those opportunities for youth who are not locked up. Third, you've got to recruit and retain highly qualified staff with skills of working with students in these juvenile justice settings who can positively impact student development and help and have creative and effective learning techniques. There has to be a rigorous and relevant curriculum for the students aligned with state standards and career opportunities and readiness. And then there have to be formal procedures, just like there are in public school systems, that ensure due process and help families and students navigate that system while in and transition into back into the community and into the educational setting there once they get out. So what does this mean? Why am I giving you all this like great aspirational language? This is all tools that parents and advocates can use if they don't think a kid is getting that, right? You can come in, print out this Dear Colleague letter from the Office of Civil Rights or DOJ and say, this is what you should be providing to my child, not a worksheet that they're completing by themselves in their room, right? It's a great advocacy tool. Okay, next slide. All right, so does an IEP follow a student entering a secure care setting, right? We just answered this. Yes, right? So the IDEA, the Individuals with Disabilities Education Act, the law that puts special ed and IEPs into place, that does apply to correctional facilities. And when a student has an IEP from a previous school and then is placed in secure care, right? That IEP does follow them, right, until it is potentially modified. So you might see this in other settings where a kid is transferring districts, where until the district holds an IEP meeting and changes the IEP, they are responsible for implementing the existing IEP until that is done. Same thing is true in a correctional setting. So now I'm actually going to ask people to use the chat function. Go back up. So thinking about, I've sort of, if you missed last week, we did a lot about, or maybe not so much, but about jail versus prison. And we actually talked about adult court a lot. So when I say jail, I'm thinking short stay, right? Juvenile detention centers in Virginia, usually at most a 6-month stay, whereas Bonaire Juvenile Correctional Center is a secure prison setting that we have for youth in Virginia. And that's the only one right now. And so the kids that are there, its length of stay is 6 months to upwards of 2 years. So they're sort of different when you think about this in the context of education, right? The juvenile detention centers are dealing with a lot of turnover, taking kids kind of as they are and putting them back into the community pretty quickly. Kids in secure settings, right, are there for a while. They're going to get to know the kid and they may do things differently because of that length of stay there. And so I wanted to ask folks to put in the chat, what is your guess about how Bonaire, our juvenile correctional center in Virginia, they have a school called Yvonne Miller High School, and it's run by DJJ's Division of Education. So if you had to guess, how do kids with IEPs do in that school? Do you think that their IEP implementation, their educational services in Bonaire are going to be better than they were in the community? Are they going to be worse? Are students going to do better? Are students going to do worse? If you had to guess, I'm just curious. Oh, apparently I gave the answer away last time. So intuitively, I thought it would be worse, right? You have this disruption in the major disruption in the child's life, where you're being removed from your family, removed from your community, and dealing with sort of like what any adolescent's worst nightmare, like a control state, right? Where you have no freedom. So I really thought intuitively that school would not go well for kids with IEPs in particular. But actually what I found in my practice, and it, like by graduation outcomes and GED outcomes, if you might question whether that's like as good of an outcome as diploma, but they actually are doing great at serving students with disabilities. And I think it's largely because the teachers in the classroom teach, they are part of the correctional education process, separate from the sort of staff that are doing the disciplinary aspects of being in a correctional center, right? I think that's one facet of it. I think another facet that is that the population is really small and kids are coming in at different stages with different numbers of credits, with different types of high school programming, generally high school students is the ones I'm talking about. And so by necessity, the correctional center has to truly individualize, right, with a capital I, that child's education in order to meet them where they were and get them where they need to go. So I think it's this combination of sort of forced participation with less distraction, perhaps, with more individualization and self-pacing that really leads to that success. That's just my theory. I would love to hear at the end what y'all think. But I wonder what lessons we can take from that when we're thinking about what our public schools should be doing. If our juvenile correctional center is having these really good outcomes, what can we take from that? Okay, next slide. So do all of the IDEA's provisions apply in secure settings, right? So here's some of my top provisions from the IDEA, right? So generally, yes, but note my asterisks around least restrictive environment. So child fine does apply in secure settings, right? The local education agency, depending on whether it's Bonaire or a juvenile detention center, it differs, but still has a responsibility of identifying, screening for students with disabilities. And actually, they're uniquely situated to do that because when kids come in, they're coming in with psychosocial evaluations that the court ordered. They're going through a diagnostic reception center and getting evaluated. And it's a great opportunity for new eyes, to look at a child in a different way and sort of see their learning patterns, see what's progressing, and maybe identify students who haven't previously been identified, or identify students who perhaps no longer have an IEP, but now should still have one. And all of that screening done, I'll just make a side note here, is another area where I think the correctional center actually excels, because oftentimes kids' health needs are met in a way that weren't met in the community. But anyway, there is an exception. I should have maybe put a teeny tiny asterisk next to child find, because there is an exception in adult correctional facilities for kids who've been convicted as adults. That once a kid turns 18, if they're in an adult correctional facility, then child find no longer applies. If they didn't have an IEP going into that facility, then the education agency there does not have an obligation to serve them and provide them FAPE. The language of that is very specific, though, because the student had to have been convicted as an adult and be an adult correctional center. And as we talked about last week, there's a whole bunch of kids, not a whole bunch, but like 75, I don't know how many kids in Virginia who've been convicted as adults, but are at Bon Air Juvenile Correctional Center. So because they're still in a juvenile facility, even though they've been convicted by adults, child find should still apply. Okay. FAPE. Yes, FAPE applies, right? Free appropriate public education. Students who are at Bon Air, students at juvenile detention centers should get FAPE as outlined in their IEP. This is true for related services. This is true if DJJ or the LEA doesn't have those folks on site. They've got a contract with people to bring them in and meet that kid's educational needs. Least restrictive environment, right? So here's a little tricky because we are in this correctional center, right? So generally we all know kids with IEPs should be treated to the greatest extent possible with their non-disabled should be served to the greatest extent possible with non-disabled peers, right? This is this least restrictive environment demand of the IDEA. But that's a little tricky to implement at times in a correctional center, and in fact, impossible at times. So LRE, right, the appropriate setting in which to deliver the child services. There are kids who come into Bon Air Juvenile Correctional Center with an IEP that put them at a private placement, right? And that's impossible for DJJ to implement because of the nature of the penal needs, right? And there is an exception in the IDEA for this. So, but the written exception only applies to adult correctional centers. Okay, so what Bon Air, what DJJ should be doing in that scenario where a student comes in with an IEP, they should be as much as possible replicating the educational setting that the student had in the community, right? Again, even if that means bringing somebody in. And so this can be sort of a point of contention for kids because they come in with an IEP that has, let's say they have like a Rolls-Royce IEP with all these services and they were at like an exceptional private school and now they're in DJJ. DJJ has a motivation to amend the IEP and really strip it clean of like all these maybe expensive things that they can't provide. But what's going to happen to that kid when that kid returns to the community, right? They're going to return to the community with a stripped down IEP. And so in the cases I've had here, I've really tried to keep the IEP as robust as possible, but then have, a narrative about not all of this can be, the parent consents that not all of this can be implemented in the correctional setting, but the team agrees that this is necessary for FAPE. In the adult setting, like I mentioned, there is a peniological interest exception, and let me pull out the exact language here. Okay, this is for students with disabilities convicted as adults and in adult prison, right? That special carve out, so not kids in Bon Air. For those, the IEP team may modify the student's IEP or placement when the state demonstrates, quote, a bona fide security interest or important penological interest that cannot otherwise be accommodated. Okay, so In other words, if we want to run a prison and not really serve you that well, we kind of get a carve out here and say that it's like in our penological interest that we don't really have to serve you if you're convicted as an adult in an adult correctional center. This is a great argument if you have kind of one of those deeper end kids and the court's trying to decide, should this kid remain at Bon Air or be moved to adults in adult correctional center? That kid gets special ed, right, through the age of up to the age of 22. And so you can use this to say, hey, court, keep them in the juvenile correctional center because they'll be responsible for getting, the correctional center will be on the hook for providing them with an appropriate IEP. If you move them to the adult correctional center, that's no longer true, right? That might be sort of a defense attorney argument, less for you guys. And then the last thing, procedural safeguards. Every IEP meeting, parent gets, okay, have you gotten a copy of your procedural safeguards? And you can file for a due process hearing and all that. All that still applies in a correctional center too. And parents and parent participation and ability to advocate on their child, unless educational rights have been terminated, those rights still apply there. And even things like manifestation determinations. I don't really hear about suspensions from school and correctional center because I think they call it by another name, but in theory, at least, those should still apply. Okay, so moving on, Rob, how does this apply in sort of a typical case? What do we see when a kid gets locked up? Well, again, these kids used to be kind of lost. And so you'll see a lot of protections in the law now to make sure they have continuity in their education. And their records have to be transferred from the sending district to either the juvenile detention center or Bon Air within 5 days of them getting there, right? And the record transfer is so important because what's in the educational record, right? The IEP. So how is the correctional center going to know how to serve this kid without that documentation? So it's supposed to get over there. And then I kind of alluded to this before, but who is the local education agency? So if it's the Department of Juvenile Justice, meaning the kid is in Bon Air Juvenile Correctional Center, then they have their own division of education that serves as the local education agency, right? And when I say that, I'm saying, who is the agency on the hook for funding this? Who is the agency on the hook for FAPE? Who do we file a complaint against if we're doing the bad job, right? That's a local education agency. In juvenile detention centers, it's actually the locality where the detention center is located. And so you might have a kid from Greene County who is placed at Blue Ridge Detention Center, which is actually in Albemarle County. Albemarle County is responsible. They are the LEA for that child while they're at the Blue Ridge Juvenile Detention Center. What was I going to say about that? Even though it is that, that local county, that local district who's the responsible LEA, the way they actually operate varies. So some kind of run their own internal school in Virginia within the JDC, the Juvenile Detention Center, and have their own teachers and that. Other ones actually do contract with the district and the district's bringing teachers in. Some have a hybrid and just pull people in for specific, special education or related services or things like that. What else was I going to say about that? Oh, there used to be, every JDC used to have a separate school system that run all the JDCs, but we got rid of that a long time ago because that wasn't going so well. And now I think things hopefully are improving, but this is an area that our office is curious about and wanting to know how students, particularly students with disabilities, are doing in the JDCs educationally. Another note I'll make is that for adults, kids in local jails and regional jails, this applies as well, right? They should be getting these educational rights. You just don't hear about it quite as much. And since the IDA goes up to 22, they still have the LEA. It's still true that the LEA, where the jail is responsible at the end of the day for providing FAPE. Okay. Let's see. Thank you. Okay, so now moving on to kind of when the kid's getting out, right? This was an area where we were really, really failing students. And I used to practice in Maryland with students with disabilities. And this was an area where we really saw problems for students with disabilities, or all students actually leaving education, leaving the correctional center and going back home. And what would happen is these kids would just not be re-engaged with school and fall off the map and drop out. So now in Virginia in 2006, we put in really robust protections for students who are incarcerated in planning for their re-enrollment, their re-entry back into the community. And so I put the administrative code down there, which is kind of where all these regulations live. But the goal really was kids should be in school within 2 days of getting out, right? And this is an ambitious goal. So how do we get there? First is notice, right? Anytime a kid might be leaving a correctional center, the school system where they're going, where they came from, the origin, or if there's an obvious other one that they know they're going to, should have notice at least 30 days before a possible exit. So I say possible because there's a bucket of kids who a court is determining whether they get out or not. And so when they have this hearing upcoming, we don't know what the outcome of that hearing is going to be. But if it's a possibility that they're getting out, this reentry planning should be happening. They get noticed with, and if DJJ thinks the kid's going to be done with their completed with their treatment, completing their treatment, then again, they should be looking at least 30 days in advance and giving notice to the school system that this kid might be coming. Then there's this transition reentry team made up of DJJ folks, made up of school system folks that should be meeting and making a draft reentry plan 25 days before the kid gets out. That plan should be finalized 10 days before they get out. And that's when the parent is invited to attend and give input. Where is this kid going to enroll in school? Who is the person responsible for literally enrolling this kid, right? We make sure we have identified that actor. What is it? And is this receiving school? The school is going to take them, accepting this kid, and this plan is in place, right? So really specific deadlines are in this. Now, of course, like any law, it's not always followed. And as parents of students with disabilities, this is not unfamiliar to you, that often it can fall on the parent to be the enforcer, right? To make sure, hey, I saw that my kid is supposed to have this transition meeting. Is this happening, right? Did you give notice? One key thing I forgot to mention was the records transfer, right? 5 days before a kid gets out, the records are supposed to go over to the new school so that they can immediately implement the IEP, get the kid enrolled. But often, again, it's the parent who kind of has to own this, and mistakes happen all the time where you see the kid returning to a school into a class that they've already completed and have credit for, or, it can happen because as a practical matter, the structure, the programming of the correctional center might be very different, right? You might have from the programming at the school. The programming the school is going to might have like block classes. So the kid's only taking 4, they're coming from a facility that had 7, right? How do we make sure that kid retains their credits, takes appropriate classes and all that? And it is a challenge. This is exactly what these meetings are for. And I kind of am optimistic that with the way, virtual service education has gone, it perhaps we'll be able to do even better job of credit retention for kids and continuity. But one thing I might not have highlighted is these re-enrollment provisions, they only apply to kids who've been locked up more than 30 days, right? I think the theory being that, kids less than 30 days didn't really get integrated into the educational setting of the juvenile detention center. And so they can kind of pick up where they left off. But I would say on the ground, that's actually a problem too, because it's still a big disruption, and it's a direct disruption in their ability to earn credits and all that and work towards graduation. Did I want to say anything about this? I think that's all I got there. Okay. So the last thing I really want to highlight for y'all is think about if you're a school system and you're getting notice 30 days that a kid is coming to you from juvenile prison, from a juvenile detention center, how do you think you're going to feel? Right? You're going to be like, ooh, we don't want this kid, right? And I think that is a little bit of a reaction that school systems have. And so how do they act on that, right? Well, let's talk about this. The kid who so imagine a school-based offense that also led to arrest and time in detention. That kid might have an existing suspension expulsion that was in place kind of when the kid went into detention. When that kid's coming back into the community, if that suspension expulsion hasn't run, that's still in place, right? We all know that a kid with an IEP who's suspended, expelled still is entitled to FAPE. So hopefully that kid is getting educational services from somewhere. But we have to let that suspension expulsion run its course. If the child was not suspended or expelled, which is very much likely to be true, because what had happened is the arrest happened, the kid was detained, the suspension expulsion process didn't actually start because they didn't have a mandatory hearing, they didn't give the notice. School systems start seeing that the kid's coming back, they get this notice and they're like, oh, well, let's suspend them now. Well, there's a law, there's a regulation in place in Virginia that says school systems can't do that. If you didn't suspend or expel this kid before he was locked up or she was locked up, then you can't do it now, right? So that's a protection students have. So what do schools do in place, right? They rely on the code section I put there, which is the alt ed. And I'm making school districts sound really bad. And I don't need to say like they all have these nefarious intentions, but like just thinking, just being a skeptic here. We've seen them rely on these alt ed provisions. So when they're having these reentry meetings and planning for the kids' return to the community, a lot of school districts are like, whoa, 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 this kid's coming from detention, this kid's coming from prison. We need to put this kid in alt ed, right? And they funnel that kid. And the alt ed statute, if y'all haven't looked at it, is sort of a behemoth. It can really, lots of stuff can go in there. And I was even, as I was preparing for this presentation, being reminded of how many things can lead to a school board being able to place a kid in alt ed. And so under the statute, so a school board may require any student to go to alt ed whose weapons, alcohol, drugs, intentional injury, or a 260G offense, which we call it, it refers to a certain statutory provision. So if a kid has done any of those crimes, regardless of where those crimes happen, right? Regardless of whether those crimes had any nexus to school, then the school system can place the kid in alt ed. And they have certain due process provisions. So in addition to sort of the drugs, the weapons, intentional injury that I mentioned before, those 260G offenses go from everything from like weapon, like gun stuff and homicide, sexual assaults, selling drugs, we talked about that, arson, burglary, robbery, gang activity, recruitment into gang activity, an act of violence by a mob, abduction, or a threat. So if you don't practice juvenile defense, you might say, cool, that's fine, right? Those are all really bad crimes. Like we're okay with making those kids to go to alt ed. But I can tell you in our practice, some of the things that my kids have been convicted of, assault by mob or something, is actually what many of us would think of as like a fight after school, right? Or robbery. Robbery is the #1 most common offense that kids commit to get them locked up in DJJ. So, and it's sort of I don't want to say typical adolescent, but it's something adolescents do more so than any other population. And so it doesn't necessarily mean that this kid is like truly a danger. Anyway, big broad statute lets them go to alt ed. Now, what I want to highlight here is though, federal law always trumps, right? Meaning the IDEA always trumps. So a school district may want to place a child coming out of a juvenile correctional center or out of a GDC into this alt ed program. But we also have to think about the least restrictive environment and where this child can get the services that are dictated in their IEP, right? And while the school system may say, oh, it's the same educational environment. Here they've got 40% of time, with non-disabled peers, and here in alt ed, they have 40% of time with non-disabled peers. I often find that if you get into the nuts and bolts of the programs, what is actually offered the students, how much exposure they have to non-disabled peers, how much access they have to, it could be career development stuff. It could be access to professionals, counseling, other services in their IEP, the ability for other accommodations to be implemented might be impaired in the alt ed setting. On the flip side, I will say I've had clients who want the alt ed setting and do well there. But I would just say as a parent or as an advocate, really think about, can the child's IEP be implemented in this alt ed statute or in this alt ed setting? And if not, if you don't think so, then what you say is, hey, my child's special ed rights trump the school district's ability to place this kid in alt ed. All right. That's a lot on reentry here. I'm going to turn it over to Rob now to touch on a little bit about kind of what happens in other walks of the kid's life when they're leaving incarceration.
So, Amy, before we do that, there's a lot of questions. I think you've addressed several of them, but so we could maybe move through these pretty quickly if we want to start to do that now. And then
I think move through them, because the way that we've done the recording in the past is we turn it off for questions, so to protect people's privacy.
Okay, so just go ahead with my section. All right. So I want to talk about what happens when your child ends up with a criminal record, which anyone in the juvenile justice system will have. So I want to talk about expungement, explain a little bit about what that is and what happens to those records after the case is over, and some of the effects that that can have. When we talk about having a criminal record, these are some of the most common things that we see affecting people throughout their life. So number one is housing. It can just be incredibly difficult to find suitable housing with a private landlord or public housing, because sometimes some particular criminal records, like drug offenses, can have a really detrimental effect on a person's ability to live in public housing. But private landlords do background checks as well, and so finding housing can be extremely difficult, and a person's options can be very limited depending on what their record is. Employment can also be extremely hard. I've seen people with shoplifting convictions from when they were very young, affect them into their 30s, 40s, 50s in their inability to find certain kinds of employment because of a shoplifting misdemeanor. Education, that's both applying to schools and qualifying for financial aid, which can be complicated by criminal record. And then the final one is, we know that folks with certain kinds of criminal records can be drawn back into the criminal legal system, in part because of the first three that you see here. So if you can't find housing, you might break into someone's house to stay for the night. Or if you can't find a job, you might steal in order to put food on your table. So the likelihood of future criminal legal involvement is, I think, enhanced by someone having a criminal record, especially when they're young. I want to also, just at the outset here, when I'm talking about what is a criminal record, it's important to know there are two types of criminal records created when someone is charged with a crime, and this is true in both the juvenile system and the adult system. The courts have records, and largely those are those are held by the court. You can't find those online, but they do exist and can become public in certain situations. And then the law enforcement have a record. And in Virginia, in the juvenile justice system, which is not the same as the adult system in this respect, when I'm talking about expungement, I am only talking about the court record. There is no expungement of juvenile law enforcement records. So the police, whenever a child is charged, even if the charges are dismissed or the person is acquitted, the law enforcement records remain and can be shared in certain situations. So I just want to make that clear. When I'm going to be talking about expungement tonight, I'm only talking about the court record. So what is expungement? Expungement, which is often called sealing, this is removing a criminal record from public view. In Virginia's juvenile justice system, expungement means total destruction of the physical court and police records. And the effect of that is, when a record is expunged, it is treated as if it never happened in the first place. That's really important. Not every state has a law that is that powerful. So expungement is it's the best remedy in terms of if you have a criminal record and you want to be able to move on with your life, expungement is the best way to do that. But of course, it's only allowed in certain situations. So I want to just take a little time and run through several scenarios and just demonstrate kind of how different this plays out in terms of who qualifies for expungement. So when you're thinking about who can get their record expunged, you want to look to the final outcome, which lawyers call the disposition of the case. So I just used grand larceny here. It's a very common offense. Grand larceny, the threshold has changed over the years, but it's $1,000 of the theft of $1,000 or more of money or property. So in each of these 4 scenarios, a 15-year-old is charged with grand larceny. In the first one, the JDR court dismisses the case. In that situation, the defense attorney can file a motion in the criminal case to expunge that record, and then it's gone. The court record will never haunt the person again. And you might think, a dismissed case, well, why would I worry about that? But when you think about a record later on, the landlords and potential employers don't always know what they're looking at when they look at a criminal record. And so a dismissed charge can definitely impact people later on in life. And in this situation, it's as simple as just filing a little motion to say, I'd like this record expunged, and the court is going to do it. So it's really a no-brainer if your kid is charged with a crime and it's dismissed in JDR, get that motion to expunge done. It will be expunged later when it's dismissed if the child turns 19 and 5 years have passed since the last court hearing. So we do have a system of automatic expungement for certain situations, and a dismissal is one of those situations in the juvenile system. Scenario 2, 15-year-old charged with grand larceny. This time it's reduced to petty larceny and they're found delinquent. Now there's no opportunity to file a motion to expunge. So if this 15-year-old is charged with grand larceny, it's reduced to petty larceny, and say the last court hearing happens when they're 17, they're going to be 22 before that record gets expunged, because they have to turn 19 and 5 years have to have passed since the last time they appeared in court. So it's going to be a while, but it's still, the court record at least still gets expunged. Now we go on to a little different scenario. 15-year-old charged with grand larceny, found delinquent in JDR. Grand larceny is a felony. In that situation, the record is retained, and there's really nothing under current law that would allow them ever to expunge that record. So even though we're talking about a child, a 15-year-old who commits a felony, if they are treated as a felony and found delinquent in JDR, that record stays with them. That to me is maybe the most troubling scenario here. And then scenario 4, the 15-year-old is charged with grand larceny, but the case is transferred to circuit court. In this situation, it's ineligible under current law, but the General Assembly passed a new law in the most recent legislative session that will allow for record sealing of certain felony convictions. So if they're convicted as an adult under the new law, which doesn't take effect for a few more years, but it will take effect, then if they don't have any convictions in the 10 years after that conviction, they can seal that grand larceny conviction. And it's as if it never happened. So in that situation, they're actually under the new law, they're a little bit better off if they're convicted in circuit court than if they were convicted in JDR. So that's just a quick snapshot of expungement. And I think now we can move on to questions.